Hello everyone, welcome to today's webinar. This is the third in our series of webinars on our consultation on illegal harms, which we published in November last year. As you know, the first webinar sort of gave a general overview of the content and sort of focus of the consultation as a whole. Earlier this week, we then did a sort of deep dive into proposals related to risk assessment in the consultation. Today's webinar is going to focus on codes of practice and sort of talk you through the broad sweep of the proposals in the consultation, in respect of codes of practice. We're going to probably spend about half of our time presenting and half of our time answering your questions. And once again, the objective of the meeting really is that at the end of this session, you sort of leave the virtual room feeling, like you've got a clear grasp of what we say in our document, what we say in the codes and why we're saying it, and that you therefore really feel equipped to pull together a well-informed response to the consultation. Because at the end of the day, this process is consultative, and we really want to get a good number of evidence-based responses, so we can make the best possible decisions when we produce our final statement towards the tail end of the year. With that preamble out of the way, I'm going to hand over to my colleagues to start walking through the presentation.
Thank you. So I'll just say a few quick words before we get into the substance on codes of practice today about our overall approach and our implementation timeline for the online safety regime. We had a few questions in our previous webinars about our strategy and about our roadmap. So we will just be recapping a few quick points on that before we dive in. So our strategy is really set around 4 pillars. We all know, probably most of those know on the call, that the Online Safety Act is structured predominantly around illegal harms, protection of children, and additional duties around user empowerment and transparency for a smaller number of categorized firms. What ties those duties together is really an assessment of risk and harm in each area and an assessment of the measures that you need to respond. We've organised all of that into 4 strategic priorities in terms of how Ofcom will focus our regulatory activity over the next several years. The first tranche is governance, and that's really about ensuring that all of the firms regulated by the Act have appropriate governance arrangements in place, that they're assessing risks, especially to children. It also speaks to decision making in those organisations, and it speaks to the priority that we want to see organisations give to assessing risks and making sure that safety is a core part of their business. That understanding of risk really needs to inform the design and operations of services. So we want online safety to have a really important voice in the room with engineers, developers, and technical teams across regulated businesses. The key point is that services have the trust and safety measures they need to mitigate risk and keep users safe. In our detailed documents on this subject, we've set out some priority harms areas that are particularly important for us, but really we want services to take up the baton in deciding how best they can protect users, and we'll provide our codes of practice today as our offering of how we think that should be done. Choice is really focused on making sure that users are aware of how to stay safe online, giving them more control over the kinds of content they see, and giving them more confidence that they can report harmful content and that will lead to action. And trust is a two-way street, really. First of all, it is about Ofcom establishing ourselves as a trustworthy and credible regulator in this space. It's a new remit for us. We've been working on it for several years, but we've significantly grown our team, and we hope to build the trust of industry that our intelligence is accurate, our measures are robust, and that we are holding industry to account in the appropriate way through our activities, both on policy and in terms of enforcement and supervision. But it's also about building trust between service users, online users, and services themselves. So giving people greater confidence that the platforms and services, apps, websites they use every day are places where they could be safe. In terms of our timeline for implementing those priorities and the key regulatory and statutory products that we need to deliver, we're operating in 3 phases. The phase that we're currently in at the moment is focused on illegal harms. So we published our consultation in November, and you can see that we're going to be working on a final statement for approval by the Secretary of State towards the end of this year, with parliamentary approval and implementation early in 2025. An important distinction to make at this point is that illegal harms do cover some important harms to children. So child sexual exploitation and abuse and grooming, for example, are well within the remit of illegal harms. But we do have a second phase focused on child safety more broadly, and that includes content that isn't necessarily illegal, such as graphic violence or pornography. We have started on key parts of that. We've published our consultation on age verification and estimation for provider pornographic content, where services themselves publish pornographic content. But there is also a more substantial and broader children's consultation coming up in the spring, and that will be something we will be talking to industry about very soon. That follows a similar pattern to implementation. So we have about a year's worth of time until all of those children's codes of practice come into force down the bottom. So that is when those green lines, so early 2025 for illegal harms, and sort of mid Q3 in 2025 for children's harms. That is when services need to do their first risk assessment and start putting in place those protective measures that we'll be talking about today. Phase 3 is focused on categorized services. It includes transparency duties, user empowerment duties, and I guess the important thing to say is this will apply to a small subset of firms. Categorization is something that we get a lot of questions about. We're happy to answer them, and it's important, but it is something that affects a far smaller number of firms than the first 2 sets of duties. And we'll be publishing our first piece of guidance on transparency in Q2 of this year, 2024. This on our website, on our approach documents. We're happy to circulate that again if people would find it useful, but if you want to dive into detail, that's where it is. And I think I'll hand over to our Codes of Practice team.
Hello, everyone. For this final webinar, and I will be running through the duties in the Act, our approach to developing the codes, and explaining the 6 core areas our measures cover. So the illegal harms consultation sets out our draft codes of practice that we are required to issue under the Online Safety Act. To assist services in complying with their illegal content safety duties, Ofcom is required to issue 1 code of practice for child sexual exploitation and abuse offences, which we'll refer to as CSEA in the rest of this presentation. 1 code for terrorism offences, and 1 to comply with the illegal content safety duties so far as not already dealt with in the terrorism and CSEA codes. So this includes the other priority offences listed in Schedule 7. And finally, we're also required to prepare codes covering other duties. In this consultation, our draft codes set out measures that are recommended for the purpose of complying with the illegal content safety duties contained in the Act, content reporting so far as they relate to illegal content, and complaints procedures, again, so far as they relate to illegal content and complaints about proactive technology. In the future phases of our work that Ali just spoke through, we will produce codes covering further duties as well. So in practice, what do all these codes mean for services? The codes measures are recommendations and therefore are not binding. Services can choose to follow the recommendations, or they can take alternative measures. Services that choose, though, to implement all of the recommended measures in our codes of practice, which are applicable to them, will be treated as complying with the relevant duties mentioned on the previous slide. So this means that Ofcom cannot take enforcement action against them for breach of that duty. Services may seek to comply with a relevant duty in another way, either by applying only some or none of the recommended codes measures. But if they decide to do that, they have to keep record of what they have done and explain how they think the relevant safety duties have been met and have regard to the importance of protecting users' rights. So I'll move on to speak about our approach and our strategy to developing the codes. And a question was submitted before this meeting around this webinar, around the process we use to create these codes, given it is a brand new regulatory domain. So hopefully the next few slides will help answer this question as well. So our strategy was to favor speed versus comprehensiveness by going out early with our proposals to protect users from online harms at the earliest opportunity. This means that we have taken an iterative approach to the codes, and we expect them to be updated in the future. Our first iteration of codes intends to capture existing good practice within industry, set standards, and work to raise standards of user protection, especially for services whose existing systems are patchy or inadequate. We recognize that there is no one-size-fits-all approach to the codes, and our strategy therefore considers the importance of proportionality. So this is why we've proposed to apply different measures to different services. This will depend on the riskiness of the service, the size of the service, the functionalities of the service, and if the service is a user-to-user or search service. And I'll explore a bit more what this means for the industry as a whole in a second. In the longer term, we plan to continue to update and iterate the codes as the regime evolves. So this would aim to reflect new online harms coming into the picture or countering new tactics being used by perpetrators. Future iterations will also be informed by in-depth stakeholder engagement, as well as information gathering and evidence analysis, of course. So I'm now going to look a little more detail what we mean by our approach being proportionate. So our draft measures were assessed via the cumulative assessment in our consultation, considering impact across the sector as a whole, and the burden our draft recommendations would have on varying sizes of businesses. So given many small and micro businesses may be low risk for all harms, we propose few measures beyond those needed to meet the specific requirements of the Act. Our definition of a small business is a business that employs 10 to 49 full-time employees, and a micro business employs between 1 to 9 full-time employees. For small and micro businesses that assess themselves as being risky, we propose more measures. These can have substantial costs, and it is possible some may struggle to resource the recommendations, but where the risks to UK users are sufficiently high, we consider that this is not necessarily disproportionate. For large services, we propose more demanding measures. So we propose to define large as having more than 7 million UK users, which is roughly 10% of the UK population. We believe these services are likely to have the resources available to meet the measures we propose. We developed our codes using Ofcom's impact assessment framework, which is summarized on this slide. Once we identified harms or risk, we presented options of how to mitigate these depending on the area of the service. Our team then considered how effective this option would be, and specialist colleagues carried out cost, risk, and impact on rights analysis. We also had specialist tech teams inputting on some of our mitigations. For codes measures involving proactive technology, we did an assessment looking at the accuracy, effectiveness, and lack of bias of the technology proposed. We also have a number of harm subject matters, some of whom are on the call today to answer any potential questions you may have, who fed in throughout the process, and in some cases, they led the development of the harm-specific measures. All of our measures are backed by evidence, which was gathered from a range of sources, including our 2022 call for evidence, the work by the Register of Risks team, desk work by drafters, work by other teams across Ofcom, such as trackers and audience surveys, and input from external experts like our work with the Integrity Institute. Throughout the development of the measures, we constantly reviewed who the measure would apply to, which we called segmentation, and this varied measure by measure. So finally, from this process, we were able to make recommendations of measures, bearing in mind proportionality, of course, to propose based on the options we had considered. Before looking at the measures more closely, we wanted to give you the bigger picture of where the codes fits in the recommended process for managing risk. The codes sit along other consultation deliverables to assist services in complying with their duties under the Online Safety Act. Once services have gone through our recommended 4-step process for managing risk that we spoke through in the previous webinar, services should have a clear idea of the risk and risk level present on their services. A service can then use the codes measure on step 3 on the slides here as part of their strategy to manage and mitigate the risk of harm to users. As mentioned at the start again, services that comply with all applicable measures in codes will be treated as compliant with relevant duties. I'll now hand over to who will dive a little deeper into the measures themselves on the next slide, please.
Hi everyone, I'm the Codes Project Manager. We'll now talk through the measures we're proposing in the consultation for the codes. We'll cover both a high-level view of the codes as a package and look at some individual measures that address specific harms, risk, or services. We also have on the website our consultation at a glance document, which has all of our measures set out and who they apply to. So as touched on a few slides back, proportionality is at the heart of our work, and this translates to our measures as well. As such, most onerous measures are suggested to only apply to large services or services with medium to high risk of multiple harms. We call that multi-risk services in the codes, or in some cases, very specific harms. Our measures we are proposing to include in the codes cover 6 core areas encompassing the design, operation, and use of an in-scope service. Start firstly with governance. This covers measures that help services build safety and compliance into its structure and processes. Then moderation, content moderation for user-to-user services, and search moderation for search services, ensuring moderation systems are appropriately resourced and trained to deal with illegal content. And then features, functionalities, and user tools. This covers several chapters and looks at where users have access to information and features which mitigate the risk of encountering illegal content. Then user reporting and complaints. Users can report and complain about illegal content they might encounter and see appropriate action be taken. And user access. Users may have access to service and functionalities controlled or removed. Currently, draft measures are only for user-to-user services in this area. And finally, terms and statements. Users can find clear and accessible information about the processes and services, terms of service, and publicly available statements. We use terms for user-to-user services and statements for search. So we'll now have a look at our measures. You can broadly look at the draft codes as some measures looking to address specific harms and others as being cross-cutting measures that are recommended to help services instill good practice and boost their systems and processes. Not all draft codes that address specific harms are being applied to services with a medium or high risk of that harm. For example, our measure which recommends services remove accounts run by prescribed organisations is applied to all services as we found it proportionate to do so based on cost and how the harm manifests in our impact assessment. So we'll start with examples of our harms-agnostic measures. Our harms-agnostic measures broadly break down to a cluster of measures which would have the effect of ensuring that large and risky services follow best practice in governance associated with management of risk. This is in our governance chapter, which can be found in volume 3 of the consultation. This includes our measure requiring all services to have a person accountable for duties, and our measure for large services with multiple risks to have internal monitoring and assurance function to assess that measures taken to mitigate harm are effective. Now, our moderation chapter. So a cluster of measures aimed at ensuring that large and risky services resource and train their moderation teams appropriately and use appropriate framework for prioritizing content review. There are a couple of measures on the slide. This includes the requirement for large and multi-risk services to provide training materials to employed moderation staff, and for large or multi-risk services to have and use a policy for prioritizing content to review. Next slide, please. Then we have a cluster of measures aimed at ensuring that services' complaints and reporting mechanisms for illegal harms are accessible and easy to use, including all services having complaint systems that are easy to find, easy to access and use, and also that all services should acknowledge receipt of each relevant complaint and provide the complainant with an indicative time frame for deciding the complaint. We have a cluster of measures aimed at ensuring services put in place clear and accessible terms of service, so that terms and statements covering the content and standards around clarity and accessibility, and also, as set out in the duties in the bill, that they cover things like illegal content, proactive technology, and complaint process, and how individuals are protected or covered by these. We also have many harms-agnostic measures applying to all services. Across our 60-ish draft measures, there are a minimal number that we recommend to all services. There are currently 13 draft codes applicable to all user-to-user services and 12 for all search services. So now get into our harm-specific measures. Again, what I believe are broad codes package with our positive impact in mitigating a range of harms. There are also a number of measures specifically targeting services with a certain risk of it. These include, in our automated content moderation chapters for user-to-user services, our draft hash matching measure. We recommend that user-to-user services with certain risk, size, or service type, as shown on slide, should use perceptual hash matching technology to detect child sexual abuse material, and that the technology and hash database meets certain standards. Both user-to-user and search have draft measures for removal or de-indexing of child sexual abuse material URLs, again, applicable to either service size or certain risk. This measure again requires certain technology standards, and that list of CSAM URLs are sourced from specific expertise. And for large user-to-user services with medium to high risk of fraud, that fuzzy keyword detection technology is used to analyze relevant content to see if it amounts to an offence concerning articles for use and fraud. Again, technology and keyword list standards are specified. In our chapters covering features, functionalities, and user tools, we have measures around default settings to tackle grooming. For this services, with existing means of identifying child users and of certain size or risk, should implement default settings where using network expansion prompts or connection lists, and further measures that the same services should provide information when children look to disable these settings or engage in other behaviours like blocking or direct messaging for the first time. And measures for large services with a high or medium risk of either or both fraud and foreign interference to have certain policies and transparency requirements if they run a notable user or monetized scheme. And our reporting and complaints chapter, we pose that large user-to-user services with high risk of fraud and large services that have dedicated and large general search services, got ahead of myself there, have dedicated reporting channels for trusted flaggers. And we proposed a list of trusted flaggers in the measure and how such schemes should be run. And as touched on previously, our user access measure regarding the removal of accounts run by or for prescribed terrorism organisations. This proposes all services when they become aware that a prescribed organisation, that's a group designated by the government, has an account or an account run for them on the service, they should remove this account. So we think it might be helpful to show how this might exist in a case study. We previously addressed where the codes fit into other conduct deliverables, but it might be helpful to see a theoretical example of how a service might apply a measure. This is very much a fictional scenario based on our recommendations and should not be taken verbatim or used in your own processes. So we start with a provider of a user-to-user service with 1 million monthly users begins their risk assessment. The service has live streaming, direct messaging, upload of images, and can identify child users. So as we touched on before, we go through this process. So the service understands the harms. Following risk assessment guidance and using risk profiles, they find they have a high risk of grooming, image-based CSAM, and harassment. I'll also touch on here that as a service with 1 million monthly users, this means they are not counted as a large service and they will be looking at our user-to-user codes and measures. This means that the service is defined as a multi-risk and would have user-to-user measures that apply to multi-risk services applicable to them, as well as ones applicable to specific risks above and ones currently drafted for all services. This means they would have 5 governance measures, all content moderation measures, the automated content moderation measure regarding hash matching for CSAM, 8 reporting complaints measures, both terms measures, our grooming measures, and the user access measure to them. Services could choose to apply all codes, none or a mix, as we spoke about before. But if none or a mix of their codes and their own measures, they would have to record measures they were taking instead to comply with their safety duties and would not be deemed as compliant if not following all applicable code measures for a duty. And as again, the final part of the service is as the regime evolves and following the risk assessment guidance, more measures may become applicable to them or may change. I think now I am passing over to explain how to respond to our consultation.
I shall recap the material we've covered in our previous webinars about how to respond. If you are struggling to get through all of the material that we've published, you can use some of our accessible and summary materials. So we've published, for example, some quick online guides to risk assessments and to codes of practice. We've published an at-a-glance document, which indicates what kinds of services should focus on which kinds of measures in a code of practice. And we've also published chapter summaries of each of our each element of our consultation. So you can take a look at those, and that should help direct you to the detailed documents, and that's where you should find all the information to inform your response. When you do make your response, we encourage everybody to use our web form. That's simply because it makes it easier for us to sort of analyze and assess the information that's sent in, so we can focus more of our time on incorporating the evidence and arguments that you make into our final proposals that we'll publish at our policy statement time. As a final reminder, the deadline is 5 p.m. on the 23rd of February, so a month and 5 days-ish still to go. And if you have any questions before you submit your response, you will have either the address that came with our webinar invitation or ahconsultation@ofcom.org.uk. So many thanks from me and the team involved today. Thanks for so many of you for being here. Enjoy your lunch and have a great afternoon. Thank you.